Two things in life are certain: death and taxes. We'll discuss taxes some other time, because today we're discussing the disposition of remains after death. When you pass away, your body will come into the possession of a funeral home. Before the funeral director may proceed with service, they will require the approval of your agent. Who can approve these arrangements, and how do you ensure funeral arrangements are held in a manner consistent with your wishes? Fortunately, the law provides a list of who can serve as an agent for your disposition of remains. The following people, in this order, have the right to control the disposition, including cremation, of your remains. The person you designate in a written instrument signed by you, your surviving spouse, any one of your surviving adult children, either one of your surviving parents, any one of your surviving adult siblings, any one or more of the duly qualified executors or administrators of your estate, or any adult in the next degree of kinship in the court order to inherit your estate. Not only do the people on this list have the right to control the disposition of your remains, but they also have a duty under the law to do so. Under Texas law, the person who has the right to control your disposition of remains is required to actually do so. In fact, they are also liable for the reasonable cost of your funeral. The person who has the right to control your disposition of remains must make final arrangements or appoint someone else to make final arrangements within 6 days of them learning of your death, or within 10 days after the date of your death, whichever comes first. If the person fails to dispose of your remains by that deadline, then they are presumed to be unwilling or unable to control the disposition. If that happens, then their right to control your disposition of remains is terminated, and the right and duty passes down to the next person on that list. If you've appointed someone to dispose of your remains and provided them with instructions on how you want your funeral arrangements to be handled, then there's probably very little chance of a conflict. However, if you rely on the government's list, then there could be some disagreements among your children, parents, or siblings on how your funeral should be handled. Any dispute among any of the persons listed concerning their right to control the disposition, including cremation, of your remains, shall be resolved by a court with jurisdiction over probate proceedings. This applies regardless of whether any probate proceeding has been initiated. Can you imagine how costly, time-consuming, and emotionally draining it must be for your loved ones to have to go through a hearing to have the court determine who has the right to control your remains? We've had to represent clients in that situation before, and it is devastating every single time. You can appoint an agent in writing to handle the disposition of your remains before the need ever arises. Your written designation is legally sufficient under Texas law if it designates a person to control the disposition of your remains, is signed by you, your signature is acknowledged by a notary public, and your agent or successor agent signs the instrument before acting as your agent. If you want to avoid stress and conflict in your family because they're fighting over your funeral arrangements, consider speaking with an estate management attorney. Properly appointing an agent who can control your disposition of remains will help to bring your loved ones peace of mind while they're grieving over the loss of you from their lives.